Good evening. Can everyone hear me? We're ready to start the meeting.
Yeah, I think this is a working group session, so we don't necessarily need to follow the normal protocol. I would like to say a prayer and also pledge allegiance if we don't mind.
Sure.
So Heavenly Father, as we gather today for this working group mission meeting, we humbly ask for your guidance and wisdom in our deliberations. Grant us discernment to see the needs of the community clearly and the foresight to make decisions that promote responsible development and activity relating to the character of our county. May our discussions be respectful, thoughtful, focused on the greater good. Help us to listen attentively to all perspectives, weigh options with fairness, and ultimately choose what is best for the future of our community and our county. We thank you for your presence with us and ask you to bless our work today. Amen. Amen. And all rise.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So do we need to do roll call?
I don't think it can hurt. I'd like to, for the record, know
Sure.
who all is here. So.
Okay. All right. I'll start it off here. Kevin Kirkwood.
Present.
Robert Politic.
Here.
Dee Dee Schott Grace. John Gresham. Here. Nicole Hunt.
Here.
Kyle DiNardo.
Here.
Dan McCollin. Diana Edstrom.
Here.
Mike Buck.
Here.
Alice Schroeder.
Here.
And Byron McDaniel.
Here.
Fantastic. So, jumping right to the meat of the matter, and usually not a problem for me for some reason. Jumping right to the heart of the matter, I asked for this meeting on the 1st of July when we had another situation occur with a application that did not have complete documents or what we consider to be complete documents. And I wanted us to have a robust conversation about what is truly required and either amend the regulations because there are stipulated documents for each type of activity that we cover from a planning perspective, from a land use perspective, that relate to what those documents are. And we've had considerable opinion around whether this is a nice to have, a full requirement, and whether it's by law something that we need to have in front of us every time we make a decision. I think because it is documented or highlighted in our regulations that it is not law, but it is something that guide our requirements. And so I'd like for us to kind of open the conversation up and talk a little bit about where we've seen gaps in the past, number one, and number two, what can we do to finalize this and not punish both our current staff and our applicants because we don't seem to have everything we need in front of us to make it a viable decision. And so with that, I kind of want to open the floor up to kind of an open conversation. I would like legal's perspective. I would like our county commissioners to kind of impart their wisdom on us. Some have played in the planning commission space. Others are just guiding us. And so can we start by talking about the gaps that we've witnessed? Nicole, Diane, y'all have primarily led that charge, but we have seen other indications where there's a gap in the process. Can we start there?
Diana Edstrom. I think I've got to ask a question before we talk about the gap in the process, and this might be a legal question. When we had that other work session, we talked about the quasi-judicial and the record. Do we have a definition of what is considered the record when it comes to our documentation, since we've got zoning regulations that say these are the required documents an applicant turns in for a packet? So how do we know what encompasses the record? And I think we kind of need to put some clarity around that before we talk about gaps, because we might not agree on what a gap is.
The record in legal terms is what was actually submitted to the Planning Commission in the form of written documents, verbal testimony, or otherwise. So the record is a legal determination, what was presented. If it was not presented, it is not part of the record.
Okay. So that would lead me to ask who determines what determines what gets submitted to the Planning Commission. Historically, for us, and this is going back several years, it's been the required documents from what the applicant's required to provide per the zoning regulations, public notifications, referrals, those sorts of things. So maybe this is the crux of the conversation, how is it determined what documents the Planning Commission gets?
Well, I think the county has reasonable discretion to determine what that is. I think this all goes back to a memo of about less than a month ago at this point, where it was determined that certain things would no longer be provided to the Planning Commission because in the county's perspective, those things weren't necessary for the Planning Commission. I'll summarize one of those issues. I know that the planning director is called upon to determine when an application is complete. And so part of the memo was to identify that she would make those determinations and she wouldn't provide all of the underlying documents she necessarily used or looked at to make that determination. So that's discretion that the county has. It's discretion that the county's exercised. And I think that's a legitimate decision for the county to make.
Okay. Let me throw this out there then. Looking at the zoning regulations, and I'm looking at Article 1F1, which is the purpose of the Planning Commission. And this is again, I'd kind of back up and say the authority for the Planning Commission is the Planning Commission, according to the Colorado Revised Statutes, is appointed by the BOCC. And so I just wanted to say that since I'm not a lawyer, but according to the zoning regulations, it says the purpose of the Planning Commission shall be to review land use applications before submission of same to the Board of County Commissioners and make formal recommendations based on the terms of the regulations, the subdivision, as well as any related regulations or plans. So I look at that, and it's to me, it's clear that that is our job. We're established and appointed again by the BOCC per statute. CDS, when I look at the zoning regulations, and that's in the same article, and it's number 13. And I'll paraphrase here that CDS serves as the advisor to the Planning Commission. They represent the commission at meetings. The CDS director shall conduct research, report preparation, other tasks assigned by the Planning Commission, and that they serve as the administrative office for the Planning Commission. So my question would be, what gives the authority, what is documented in the county processes and procedures, and you've been talking about processes and procedures, what is documented to give CDS the authority to determine what the Planning Commission feels is appropriate or not appropriate in their decision-making process when the zoning says it review land use applications. And there are requirements in the zoning as to what goes into those land use applications.
Commissioners, I need to ask a question. Essentially, I'm being asked to give legal answers and legal advice to the Planning Commission, although my role is advisor to the Board of County Commissioners. I'm happy to continue on this path, although it is odd, and I am welcome to entertain an executive session if the county commissioners wish to have one. This is a strange conversation for me to being put on point on an issue that I believe the county has decided. So what would the county commissioners like for me to do?
Well, can I interject real quick? From a legal perspective, I don't know, but what I don't want to do is discourage the Planning Commission from being thorough. But I do know that Jennifer has recently become aware of some privacy issues that were brought up. Jennifer, can you talk a little bit about that with, as far as the applicants are concerned, and that you've changed some of the things that are included in the packet, or and I think it's been in the last few months that we've become aware of some privacy issues with some fraud emails and some different things. Can you elaborate on that a little bit?
Sure, that's all correct. A couple of points about that. There is, I believe, state statute that requires the county to protect personal identifying information, I believe is the term that it uses. In relation to that, a local example is a number of our applicants have been receiving fraudulent emails following the posting of the packet. There are emails that appear to come from county staff or from the county in various ways, asking for payment for a decision at the upcoming hearings. Luckily, at least to my knowledge, our applicants have asked about it. They're typically pretty big numbers that we've been seeing, $8,000 and stuff in that range. And so I had discussed with previous legal counsel about how to address that, working with IT. We don't have to get into all of those details, but that it certainly is a concern and something that we need to address in some way. Redacting materials is certainly an option. There is some concern as to the effectiveness or necessity of materials once they're redacted and the time that it does take to do that and have those then included. And so, again, in response to all of that, among other things, certain proposals have been put forth as an option.
So the reason I bring that up is that it would be future date. I would like to talk amongst ourselves what should be included in the packets, come to an agreement on what should be included in the packets, and then have a checklist that you sign off on or someone you designate signs off on, and that's included in this packet. They can say, okay, everything we agreed on is in the packet, and it's all okay. And it's signed off by all of comfort that the packet was complete. And that could be something, this type of, it's a rezone, these documents should be in there. It's this type of an application, these in there. It shouldn't be rock and be, there needs to be some common sense things that we decide for the planning commission.
We're catching about every third word, Mike.
Byron, can we not have a checklist?
We do the
Don't
zone.
like the checklist idea?
I think he was agreeing that he wanted a checklist.
I was saying, could we not, once we get this done, just get a check, make it easier for everybody, we just check it off and get it done. And then, Lance, sorry, I was muted earlier when you were asking the question. You know, if you feel like we need to
I'd like to get as much accomplished tonight as possible, but if you feel that we need to go into some type of executive session to discuss this, we certainly can do so.
Thank you, Mr. Chair. I'll leave that to the board if you want to do that or not, but these are legal questions that the board has not had a chance to ask or receive answers to. It's odd for me to give those publicly before the board's even had a chance to digest them. So that's why I throw it out there. We can continue on this path if the board wants, but my advice is typically privileged for the board. In this setting, it would not be privileged at all.
And so I actually agree with you. So I think we can get to a point where we can look at the elements associated with the lists that are out there and make a fundamental decision on whether they are required or not. As an example, I've seen deeds. Deed should be just a checklist item. Did you check the deed? Is it viable? And is this the person, or is this the owner of this specific lot, area, et cetera? To me, I don't ever want to look at a deed. I don't think it conveys much. We've seen some pretty interesting deeds with a lot of history. But again, I don't think I need to see that to make a decision around a land use application or a special use by review or any of the elements that we're charged with. So I'd like us to refocus and get to the list and look at the items that are in each case by their create a checklist, an agreed upon checklist. I think to Mike's point and Byron's point, those are the kind of things that we need to be put in front of us and ticked and tied every time. And there are things in there that I am never going to look at because either A, they don't make sense, or B, they're irrelevant to the decisions that I need to make from a quasi-judicial function that allows me to render an opinion of whether this is compatible, in alignment, answers any of the questions that are on our checklist of the elements that we need to use to provide our recommendation. And so there are things that I think are in there that are extraneous. But again, I'll point this at Nicole. I think there are things in each checklist where you have taken a hard stance, and let's talk about those for just a minute. And let's focus on the ones where we've seen a gap here recently and use that as a foundation for the discussion. Don't mention the land use, but do mention the missing documents and the elements that kept you from being able to use and make a full decision.
Well, thank you. Thank you for that. I'd like to maybe just back up that, in my opinion, the zoning regulation, the purpose of the Planning Commission, and it does say specifically in the zoning regulations that the purpose of the Planning Commission is application. That's in Article B.
Can I make a recommendation real quick? Can we turn off the video of each one of the players? Because it will keep you from getting the words across. So that's why Mike we were breaking up a minute ago. And sorry, Nicole, you want to try to continue?
If others can. Okay.
Yeah, this is Byron, I can hear you.
All right. Perfect. So what my point was saying that in Article 1, it does specifically say in the zoning regs that the Planning Commission is to review the land use application. And then if you look at Article 2 of our zoning regs, B, it says that the table below identifies the documents that are part of the application. So I personally am not going to be submitting the entire application to the Planning Commission. We need to change the documents because according to the zoning regulations, the land use application is all of those documents, not just some of those documents. And yes, is saying, well, we think you only need these. This is all. According to the zoning regulations, it defines what the application is. and it's the application is in its entirety, not of it. And so I think that's something that we should take into account. I don't know that without changing or amending our zoning regulations, that technically speaking, we're allowed to pick and choose which parts of the application are applicable. Next thing I would say is that of the documents that were suggested tonight, I particularly don't agree with withholding the public notice documentation. I think that's part of the due process that is important to the applicants, but also to the public, so that they know proper documentation and notice has been submitted in the project. So that's one in particular that I would like to see stay in our documents if we're not going to be providing the entire application.
Yeah, I think that's a simple ask and easily achievable. I think to your point, Nicole, we do need to change some of the regulations, and we do need to agree on what that list should be. So we can go through the list for each one of the areas tonight and make a decision, or we can ask staff and the planning director to help us make the recommendations in alignment with the Board of County Commissioners and with legal at the table. What I would ask legal to do, instead of opining on whether this is an issue, opine on whether the packet is complete or not, and whether we can make the judicial or quasi-judicial decisions appropriate to the land use or the special use or whatever the case is that we're looking at. Does that make sense? That also takes some of the heat off of some of the questioning that we're doing, which isn't fair as well. So I would kind of like us to go through the list tonight, if possible, and show what is we consider to be completely in and what can be stricken. My example, the easy one, was the deed. I don't think I need to see a deed. I do need to know that staff has checked and validated that the deed is current and compliant. And where are we exposing the PII, personally identifiable information? Specifically, which documents?
I don't know where exactly they're pulling it from. I know when all of the documents are included, phone numbers, addresses, email addresses are on multiple documents. And so it was explained to me from IT staff that that's where they believed that was coming from.
Sure, the packet would include things. It's not truly PII, it's business card information. But because they're in front of this body, it kind of constitutes the idea of personally identifiable information. Wow, English not me tonight.
Yeah, that's okay.
But again, there are things I don't necessarily think that we need to redact them, but I think we can omit some of those elements from the package so it's less identifiable to the individual that's making the request or getting the whatever the case is that we're reviewing. So is that something that's easily doable? And I think there ought to be an IT function that ought to be able to help us out with that. And I think there's a way to look at the metadata. Sorry, I'm using big words, but metadata associated with how phone numbers is structured, as an example, or an email is structured, and programmatically rule that out. That allows us to completely share the information without hurting the individuals that are in each case.
Or create a cover sheet that has all the pertinent information that is necessary for the county to be able to process the application, but then that cover sheet is referred to in the supporting documents to obtain, applicant information and so on. That way it never enters into any of those potentially public documents. That to me is the easier way, for Jennifer and staff to be able to handle that. without having to go down the road of trying to come up with the ability to have an app go through based upon a query or a search to be able to redact that information before it hits the website.
Sounds like you're volunteering to help.
I can?
I figured you could.
Yeah. Oh, we don't mind sharing.
Just make sure you're talking into the mic.
Yeah. Anyway, that's my idea, to make it something that can be actionable in a relatively short period of time, to be able to have, final decision on that's what we're going to do.
Okay.
Versus the other, which would be time. And IT people rolling their eyes at us.
I like making IT people roll their eyes. I'm in security, so.
Yeah, I know.
So refocusing a little bit back to the list, fundamentally, I want to get to the goal tonight, if we can, where we never have a case where we turn down an applicant or move an applicant based on the fact that we think the document's incomplete. Because we have heard a number of cases where I feel that we had enough information to logically make the decision, and a lot of the documents that we were missing, to me, were extraneous, didn't change my decision, didn't change whether they fit the criteria for selection.
Well, let me ask, maybe this is or isn't a legal question, but one of the things that we ran into with a most recent application by a very big company was the fact that they decided to move forward even though the application was not complete and they hadn't resolved the referrals, but they decided to move forward. And so is that then become a situation where we simply deny it based upon the fact that they didn't complete it, or do we adjudicate based upon what was presented and take whatever path we choose based upon that, and then they have to regroup and decide what they're going to do? And that would be the same for any applicant, because if CDS has done their job, they have worked with the applicant saying you have to provide this, 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 and this. And, based upon that, we're going to set a date and time for your review before the Planning Commission. Like you said, maybe some of those documents are extraneous, or they are very pertinent to the fact that we will deny that application, and they have to regroup, So I don't know, where do we stand on, developing a hard line, versus taking what we have and the information we have and the current rules and regulations that we are to consider when looking at this application to make our recommendation to the Board of County Commissioners. They can always change our mind, with maybe, the D wasn't, the T wasn't, dotted and the I wasn't crossed correctly, but then, based upon our recommendation to them and saying, we recommend, denial because these things are missing, but they can always, within the time frame of, it being presented to them, those documents come in. And now we're not slowing the process down.
Yeah, no, I get where you're coming from on that.
Okay.
And I remember the case, and I was looking at it going, okay, so staff recommended that we disapprove or recommend disapproval.
Right.
And we looked at it. We did, I believe, recommend not approving that personal or exact situation, but it wasn't a case where we were delaying or hurting both our staff and the applicant. The applicant was actually hurting themselves in that case.
Sure.
And I'm fully aligned to the decision that staff made, and the fact that sometimes the applicant becomes a bit of a bull in the china shop.
There's the bull.
Speaking of bulls. But, so any other thoughts on that?
Well, in going back to say, like you said, and again, maybe this is, another way that we can look at it is say, for any application, here's the bare minimum requirements. And that's what staff then works with the applicant to make sure there's that bare minimum. But
you are not allowed to unmute. To raise your hand, press *5.
Okay. And then a tiering based upon the complexity of the application. For
you are allowed to unmute. To unmute yourself, press *6.
Yes, go ahead, Jennifer. I think you're
Lose audio, Mike?
hearing what I'm saying.
What's that?
Did we lose their audio?
Yeah, I did.
I did
can't
too.
hear you anymore.
I just told them in the chat.
It has our mic is muted.
Yeah, up top.
Can I make a recommendation? We do this all in person and not use Zoom.
This is Teams, though, isn't it?
No,
You are no longer muted.
Oh, yeah, it is.
Perfect. Can you hear us now, Mike?
Yeah, thanks.
Yes.
Awesome. Okay.
Right.
Take 2.
If I may, I would love to provide just a little bit of context and maybe a little bit more information and speak on behalf of CDS staff for just a couple of minutes, if that's okay. I think we all have the same goal in mind, right, which is to create, to improve the process, to create consistent expectations so that every time, right, that the Planning Commission or the BOCC gets a packet, they know what's going to be in there, so that every staff person creates the packet to be the same, so it's not in a different order, right, or sometimes this is included and sometimes this is not. So I think hopefully we can all agree, right, that that's kind of the goal, and that's where we're trying to create some consistency and some better processes. There's certainly a variety of ways to do that. And to provide, I guess, a little bit of context, I think we're trying to achieve multiple goals through this, right? Like I said, I did put together a memo. Again, maybe or maybe not that that's the way to go. We can certainly make some changes to that. It's at least a starting point, right, and got us all talking. I do think that there are some different issues being discussed, right? One is completeness. And I will say that my reading of the regulations, completeness is outlined. That is a staff level function, and that is determined at the beginning of the process. So that's, again, my reading of the regulations, that's how that's handled. So completeness is probably a different issue than an incomplete application coming before you, in quotes, right, incomplete, which happens very rarely. It has happened, and I know you all know that, but that's probably less likely. I think the more common issue is applications that have been deemed complete, right, or I guess where we're trying to go is applications that have been deemed complete at the beginning of the process, go through the process, and then putting together a packet for you all, both groups, right, that includes all of the information you need to review the application against the approval criteria without including a lot of documents that you really don't need to review in terms of the approval criteria or completeness, because that's already been done. And for just a little extra information, I will say I did do some research on not just my personal experience in municipalities, but other counties in the area and other counties of a similar size, and including all required documents is not the standard. I'm not saying we can't do it. Staff is happy to do whatever the group and the BOCC, right, directs us to do. And so but I do want it to be clear, I'm certainly not trying to withhold information. That's not the goal at all. I want you all to have everything that you need to make a recommendation and a decision on the application itself. Have there been mistakes or problems in the past? Without a doubt, I'm sure there have. I'm happy to do everything we can to work through that. I'm hoping that we can figure out how to work through that together, right, in a offline setting that's not in the middle of public hearings. And hopefully you will always have what you need to make those recommendations. And so I'm just hopeful we can get to that point, so that it's as easy as possible for you all, because you have the really hard decisions in front of you all. And so I want to be respectful of your time, understanding you only have a little while to review those. You don't have months, even though it's been active for months, you all have, sometimes 4 or 5 days to review that, and want to be sure that you have a concise group of the information that you need to make a recommendation or a decision on the question at hand. And the final piece of it, and Lance can certainly add anything if you would like, but the final piece is making sure that we are not jeopardizing, a planning commission recommendation or a BOCC decision by having other statements that could be cause for alarm or concern or legal action, And so that's why we are trying to really focus on the review criteria, the question at hand, and hopefully getting to a point where you all are comfortable that the other work has been done on the front end in terms of, is this person actually the property owner, and can we check the box of required items? And so I just want to clarify that required items being submitted, in my mind, is different than being included in the packet. And I know there are various opinions about that, but if we can just maybe clarify that as we move forward, I think that'll be helpful.
Yeah, one of the things that I think everybody here is concerned with is what happens if we have a document that could skew the decision in a different direction, right? And I don't have a specific case in mind or a specific area, but I think it becomes an open question as to, if we don't have everything in front of us, can we make the rational decision? I think, again, I love traffic studies. I read the traffic studies. That's good information. I don't read the deed. Don't care that the deed's in there. In fact, that contains more personally identifiable and challenging information, because we put something online. It can be copied. It can be skewed. It can be somebody can steal property using that method. And so, as I'm looking at this, I wanted, there's a trust factor as well, right? Do we trust the information that we're getting from the CDS, from the planning group? And so I'm throwing a couple things in there that kind of skew it a little bit, but I think we need to get to good enough, and good enough is where we've agreed that we've got the bare bones minimum for each case, with a focal point for the items that are not essential and could cover some area where security lapses or some kind of risk occurs. And I'm happy to work on that side of it. I do have a bit of experience in it, and I know Robert also has some pretty good experience. I think we can get to a point where we have a good recommended list of the items that are 100% needed to be in there every time. Now, do we want to go through that list, or is that too painful and we need to do that in a separate, more private conversation? Not necessarily. If we are focused on
if there's not a quorum of either body in the meeting, it wouldn't have to be in the public setting. So would it be a subcommittee that could be formed that could report back to both BOCC and Planning Commission as a whole? That would be private or public. I agree with what Robert said earlier about the completeness there, and being able to make a decision one way or the other on a application, so that it continues through the process. And if there's issues with an application, that there's a thought that there's some documents missing, that does give the applicant an opportunity between PC and BOCC to make that up, so to speak. So I like that, that thought along there. And I agree with Jennifer as well. We need to make it so it works for everybody, and really looking what other counties are doing and how they've interpreted a complete application. I certainly assume that when a application comes before me and staff says it's complete, that some of these things such as the deed and so forth have been checked on. And so I think the trust factor has to be there with staff as well, that they're doing their job as well. One thing that might work, and I'll just throw it out there, these extraneous documents that perhaps some people want to look like, but we don't want to put in the packet, could still be made available, I believe, in the CDS office. If someone wanted to come and look at those, they would be available, but that wouldn't then be disseminated publicly. So just a thought to get the idea from Lance too, if he thinks that's a good idea or not. But it would make it available to the planning commissioners that wanted to see that.
On that one, I'll weigh in a little bit because it was part of the larger training and work session we had with the Planning Commission previously. There are some due process limitations to what has to take place when you're in a quasi-judicial hearing. And the decision itself needs to be limited to those things that were presented in the record. So there are the written materials that are actually submitted. There's all the conversations on the record that take place. There's the testimony that takes place. There's the presentations from staff and the applicant. But in every case where there is a quasi-judicial hearing, I would say the decision maker, the judges, should not be doing their own independent investigation. That is its own due process issue. So if you're getting additional information, that is some level of an ex parte communication that causes due process concerns for the process itself. So if you get information, say for example, you're at a grocery store or somewhere and someone comes up to you and starts talking to you about an application, the only way to make the process complete is to then come, and every commissioner that received extraneous information would need to disclose that on the record and the circumstances, and that would then protect the county and the record from challenge. But in general, you should avoid, every person who serves on a quasi-judicial body should avoid those types of communications and that type of independent investigation. So it is one thing that's very different if you happen to have personal knowledge. For example, maybe there's an application that's about a half mile from your house and you happen to know the neighborhood. There's not an issue bringing that personal knowledge to the table. You didn't go investigate to acquire it, you just knew it. And you might have questions related to what you know. That's perfectly legitimate for consideration in a quasi-judicial hearing. On the other hand, if you're going out and taking your own pictures and getting your own vantage point and you want to see a property from every angle, maybe you have a drone, maybe you're a hobbyist and you get some great pictures around the perimeter as you think it exists, that's a different issue entirely. That is an investigation of your own that is outside of the record that's available to the rest of the body, and that's no question a due process concern. So when you're talking about coming in and looking at records that aren't otherwise going to be made available to the body, I would have that same concern. That's an independent investigation that is outside the record.
Okay, that makes sense. I appreciate that. So then I guess we go back to where I'm at, is that there needs to be some trust factor with the staff, that they have done these processes, particularly if we're looking at trying to protect personal information from getting out there.
Oh, let me just chime in for a minute because, Kevin, you had asked at the beginning about personal experiences as a planning commissioner and with the documents. So I came onto the Planning Commission, April 1st was my first hearing, and for all the ones we've had, I have, I've voted no on a bunch. We've continued 3 different packets. The ones that I have voted no on have been, and it should be in the meeting minutes, it should be in the records of all those those meetings as to the discussions that we had, why I voted no or how anybody else voted, because it was delineated so that when the application got to the BOCC, since we are supposed to be making recommendations to the BOCC, that information would be there. Most of the time it hasn't been. I've sat in, and I know Dallas knows, I've probably attended a good amount of the BOCC meetings where the land use hearings for what we had sat on were heard, and the vast majority of the time there's not been recommendations provided to the BOCC that were made by the Planning Commission. In general, it's been, here's how the Planning Commission voted. So they're not, in my opinion, the BOCC is not getting the information that the Planning Commission has, spends a lot of time on reviewing the documents. That's an issue to me. I'd say if that's the case, why do we have a Planning Commission?
That goes into your criteria for why the case didn't meet the rule of the case, and why you made the decision to not approve,
not
or recommend to not approve.
Yes and no. The no part is on the ones that I have voted no, and again, it should be in the meeting minutes. It has been because there were documents that were missing. Some of them were public notification. Some of the ones recently, we did not have correct names on documents. There was missing information on documents. And going by what the zoning regulations say our purpose is, which is to use the zoning regulations to ensure that what we're getting complies with the zoning regulations, they haven't. And
but there's where you go a little bit astray. Hang on.
Can I finish?
You have to focus on the criteria, not the regulation.
Can I finish?
Sure.
Thank you. We are supposed to be following the zoning regulations. If staff says we're not, I'd like to know if our job, according to the regulations, are specific to what is said, or do we just make individual decisions and say, well, I don't think this is important, or somebody else might not think it's important. So I could be completely wrong, and if that's the case, then I think we need to change the zoning regulations to remove the purpose of the Planning Commission, which, I had read at the beginning, I can read it again, and remove any other documents that it says are part of the application, and change the zoning regulations rather than make individual personal decisions as to which documents I might think are important or Kevin might think are important. I would say on the deeds they are important, and I could tell you why, but I don't know if we want to go down that road. Because I think what I'm hearing, and I could be wrong, is that we're deciding as a group what's fair or what's not fair, or what applies to this or doesn't apply to that. So, and again, that's why I voted no, because the trust factor isn't there. And we had this conversation with Mark Dettenreiter back in April, I think it was, when we continued 2 applications, and he basically said, you have to trust us. And Jen, in your memo, you said, rest assured, this has been done. But I look at these documents, and they're not accurate. Not all the time. I'm not saying all of them are inaccurate, but we've got something coming up where we've got deeds that are wrong. So why the Planning Commission shouldn't be looking and making sure, as a quality check, if you will, to make sure that what we are getting is accurate. Everybody makes mistakes, everybody misses things, but if these are, the decisions become, and I'll use the term loosely, a legal document, and if we're approving things that the information is incorrect, that just doesn't seem right to me. So that's my thoughts on that.
Quick questions, or a couple of questions. Applicant comes in and is wanting to make a change or fulfill what they want necessarily for an application. They work with the CDS staff to complete the documentation, to work through all the rules and regs to make sure that they're complying with, and at some point there's a determination that is accountable to CDS staff that that application is complete. And that's part of the jurisdiction of the CDS staff, correct?
There are provisions in the regulations that say that, yes.
Okay.
There's the pre-submittal meeting, there's the determination the application's complete, it then starts through the process. There's a variety of provisions that could lead to that conclusion, yes.
That leads to that conclusion. And they're the ones that are held accountable for that conclusion, correct? Within the confines of any applicant and any other kind of legal recourse that that particular applicant can have, it is the body of the CDS who has made that determination.
Yeah, I don't know what you mean by, well, I forget the word you use, but they're responsible to make that determination. Certainly, if the county manager or the board doesn't feel they're doing an adequate job, there are means to deal with that. But it is their responsibility, yes.
Okay, it's their responsibility. So, and then they make they set a schedule for then, and within the current confines of any timelines associated with an application, then they set the date and time for the presentation of that application to us as well as to the Board of County Commissioners. My question would be, is it within the current policies and procedures, rules and regulations, whatever you want to call it, is it within our purview to make a determination that that application is complete, or them, the CDS staff?
My interpretation is it's probably CDS staff. The role of the Planning Commission isn't, to me, as I read the regs, to determine whether the application is complete. It's to determine whether the application meets the approval criteria. And that is a different level of determination.
Okay.
I look at it and think of it in context of planning manager, planning clerk has the responsibility to bring the information as best suited. The role of the Planning Commission is judge. It is not a clerk position. It is not a planning department position. It is to judge the case that's been presented in front of you. Does it meet the criteria? And I think if we start all thinking that way, we will get to a common ground where CDS can give us the information that we need at hand to make the decision, regardless of whether we think the application is 100% complete or not. We cannot be tied down to a full set of rules and regulations. Otherwise, we will never do business in this county. It just won't flow.
Mr. Chair?
Yeah, Nicole, go ahead.
Mr. Chair? I just wanted to, I think it's important in this very moment to clarify what it says the Planning Commission's purpose is. And as was mentioned before, the purpose shall be to review land use applications before submission to the BOCC and make a formal recommendation based on the terms of the Elbert County zoning subdivision regulations, as well as any related regulations or plans. That is what the zoning regs say. So I would contend that anything that's in the zoning regulations and is relevant to the application should be reviewed per our zoning regs.
Yeah, hey, can I interject real quick? If I'm hearing this correctly, Nicole and Diana are saying, if you look at our regulations, we're gonna have to rewrite some of our regulations to make this work. Because it sounds like we are operating outside of our current regulations, based on what I'm hearing. I'm gonna add something else real quick. One of the things I don't want to do is look at whatever is determined as an incomplete or a complete application. What I don't want to do moving forward is have something incomplete and we decide to make it up for the BOCC meeting. Oh, well, let's put it in there and we'll get it in time for the BOCC. No, these packets need to be complete and determined that they were complete for the Planning Commission to review them. I want a first set of eyes. I want a second set of eyes. CDS being the first set, Planning Commission being the second set. Then we review these docs as the BOCC, not make it up and move stuff forward to expedite applications. That's not the goal, is to see how fast we can process land use applications. The goal is to make sure we do it right and to make sure we do it the same every time and have some consistency in how we do things. So I would like to add that, but I would also like to ask Lance a quick question. Lance, you mentioned that we are not, or Planning Commission members or Board of County Commission members are not supposed to go out on field trips and, you know, do their own thing with a drone or do any additional recon, if you will, or investigation into the application or the site, but we pay a site visit fee to Planning Commission members if they want to go out and visit the site prior to the meeting. So I want to see if I'm looking at that wrong, or if you could elaborate on that a little bit. But our guidelines and our pay or reimbursement for Planning Commission members includes a site visit reimbursement fee. So I think I added a bunch of extra stuff in there, but so a lot of topics.
So
Any thoughts on that, Lance?
Yeah, I'm happy to weigh in on that, but I'll stand by my advice that you don't do an independent investigation. It really is a judge sitting in front of a trial. The judge is there to weigh the evidence presented, not to develop his own. So having done this for a number...
So should we... Sorry, I was just going to say, so should we stop doing or recommending site visits and eliminate any reimbursement for site visits and just eliminate that portion of our thought process immediately? It sounds like we should do that immediately.
Yeah, I have no opinion on reimbursement. That's kind of a side issue for this, but I would say that I would not encourage, and I certainly wouldn't require, independent investigation by anyone, whether it be the Board of County Commissioners or Planning Commissioners, as they're about to consider an application. If there's information that is expected to be evaluated, there needs to be a way to make sure that information is presented by planning staff, by the applicant, by someone, so that the bodies feel they have sufficient information to make a decision. So there's different ways to do site visits, there's different ways to see sites, there's still photos, there is drone footage if that's particularly helpful. But let's pretend for a second that after all the information is presented, because this question kind of keeps being asked without being asked, there's something missing. For anyone who is voting on the application, be that a planning commissioner or a commissioner, there just is something missing, and it relates directly to one of the approval criteria. What I would tell that individual every time is then you cannot possibly vote yes. If you feel that approval criteria has not been met based on the record before you, then you have to vote no. That's what the record means. And so if there is simply missing information that cannot allow you in good conscience to vote for an application based on the approval criteria, then you should not, because the record does not support the decision. I suspect many individuals could reach different conclusions on issues like that, But that's the law, is if the approval criteria are not met, you cannot approve. And the flip side is if the approval criteria are met, you must approve. Those are the legal parameters we work with, but it is based on the record before the body, be that the Planning Commission or the Board of County Commissioners. And while I've got the mic, I want to address another issue that was kind of asked. Sorry, I'm drawing a blank. Too many things on my mind. Yeah, I'm sorry, I'm going to have to come back to it. But bottom line is the record is critical. The record is presented to the decision-making body, not developed by the decision-making body. It is important that it be sufficient enough for either the Planning Commission or the board to make a decision. I think there's reasonable interpretation to be had what that is. And I think whether a regulatory change is required or not, we can get to wherever the board wants to be. I don't necessarily interpret the language of the purpose of the Planning Commission as rigidly as some of the planning commissioners do. I think the board has some role in that interpretation. I think planning staff has some role in that interpretation and presentation, but I do understand there are some interpretations being offered by the planning commissioner that lead to the conclusion that any piece of information that's potentially available must in fact be provided. Ultimately, I'll do what the board wants. I'll help staff do what the board wants. And I think these interpretations are really the board's to make, not necessarily individual planning commissioners, but I think there's conversation to be had about some of these interpretations. Yeah, I wish I could remember what I wanted to address, but I'll bring it up again if it comes back to me.
If I could just put a little more background on what Lance just said about the interpretations. We've never had any training as a planning commission. We're supposed to have training per the zoning regulations once a year when the board gets constituted. So speaking for myself, how would I know that my interpretation is good or bad? And who would make that decision? Who would guide us? Who would direct us? The attorney is, Lance, I understand that you represent the BOCC. Who would guide us in that when we haven't had meetings as a group to discuss this, to work through it? I know that Commissioner Buck, when he was on the Planning Commission, had mentioned they hadn't received training, so there's something missing in there. And since I have the opportunity, I will just throw in that I have emailed the commissioners about 3 times asking if I could get some planning or get some training together and get some work sessions for the Planning Commission through DOLA, which is free, but I know you guys are busy, but nobody's gotten back to me. But it would be really helpful to have that type of training and these discussions, because I think part of the reason that we're where we're at is because we don't have any continuity or discussions. And just one quick thing on the site visit, the Planning Commission's roles and responsibilities document that is up on the county website that is also guidance for us hasn't been updated in almost 10 years, and that does address site visits. So, maybe what we need to be doing here is go back and look at what our guiding documents are, if you will, again, have discussions on what the zoning regulations say, and come to some decisions rather than kind of to Band-Aid things at this point and say, well, we don't need this document or we do need this document, when there hasn't been a discussion. And Jen, I know when you issued your memo, there was no discussion with us as to what we thought we needed. It was just a unilateral decision by CDS, and I still would like to know what processes, procedures, documentation CDS has that gives them that authority to make those types of unilateral decisions. There has to be something documented, otherwise it's just one person's decision. So, thank you.
All right, so
Can I make a recommendation?
Yeah, Mike, if you don't mind, Kyle was about to talk for just a second, so let's get Kyle in there and then we'll
No
get
problem
you.
at all, Kyle.
yeah, so
Yeah, go ahead.
I've read this zoning code 50 times in the last hour, and I really agree with Lance. There's not you can take it either way, right? There's not language that it states every single thing of that application needs to be provided to us. Our job here is to review, in this, let's say, special use for by review, is to review the entitlement that's being proposed and make sure that that meets the approval criteria. I think everything on that memo, the one thing I had with Jennifer, the issue with was the application form. But I've done 10 plus applications being on the other side of this. That narrative that Elbert County requires includes every single thing that we need that is, you don't need to read the application form. And I've worked with CDS for the last 8 years on the other side. I want to say thank you. I think CDS is getting a couple things thrown at them, and I feel like they've been extremely helpful as an applicant. I think they are trustworthy, everybody that they have on that side. But I think we're going down a road of the language that's proposed in the zoning regulations and how it's being interpreted, when our job is to not here argue with the county or CDS and really just review the applications presented in front of us and see if they meet the approval criteria. This is going to be fun behind us. It's just starting. But I mean, going down the list of the application, there's numerous things in there that are not going to change our decision. Tax certificate is not going to change my decision. A lease agreement, being on the applicant side of it, I don't want to share it with you, and I don't think it's going to change my decision. Affidavit of posting a sign on a property, staff reviews, every application has to be provided an affidavit. That's done. Staff, and one of the great thing about the county is provides noticing. They don't require the applicant anymore, and I hope they don't change that, to go out there and then do certified mail, that we had to do all before. So I think the memo may have been a shock to all of us. I agree with that, but I think it was a great starting point. And I do agree that those forms that are being excluded do not change the opinion as us as a land use board.
Mike, you want to weigh in?
Well, just a final comment. I agree with everything he just said, but I do agree that it sounds like, and I don't have our guidelines in front of me, I haven't read them in the last 48 hours, but I would like to revisit those, make sure there's not any contradictory language that we're stumbling over, trying to be on the same page. So it appears from what I'm hearing that there's certain language that we need to, reinterpret, rewrite potentially, and make some changes to it. We are going to be rewriting a lot of our rule and regulations. I would just say we could add this as just something else that we look at and make sure it works for everybody and everybody's in agreement. Like I said, I don't have it in front of me, but it sounds like there's language in there that is confusing.
So your proposal was a working group session that I think Dallas called out a minute ago?
No, I just think we need to look at it again. Like I said, I haven't read it recently, and I think Diana and Nicole are reading different things, and there's different perspectives on what needs to be included and what's not. And that needs to be spelled out better so that there's not this gray area.
Yeah, there's a list of 42 documents starting on page 32 of the rules and regs that line out each one of the use cases that we have to follow. And the question becomes, is it the letter of the law or is it the intent of the law? And I think CDS is operating under the idea that it's the intent. And I think I agree with that, right? There are some things that I'm never going to want to see, never care to see. And so if we can provide some feedback on what those things are as part of a subcommittee, we can actually feed that into CDS. And it may be easier for some. They may say, I want to see everything. Others may look at it and say, I only want to see these 15 things, whatever the number is.
And there's some that go ahead.
Go ahead. And there's some that.
I was just going to say there's some that just have to be in every packet. Those should be mandatory for every packet. There should be some that are optional unless it's a special request for a certain document, something like that before the meeting. Hey, do you mind if I see this? Do you guys have that? Maybe some of that, but I don't think it's rocket science. I think we can agree on what's mandatory for a packet and come to that agreement. And some of it is just optional stuff. That's all I had.
Thanks, Mike. Appreciate that. Byron, anything?
I agree with what Mike just said, and I think we've got to just add it to our list of many things to review and update.
Absolutely. Do we want to put together a subcommittee? I kind of like the idea of doing a kind of a quick hit recommendation based on the individuals and feed that back into Jen from a county perspective for something that we can collate and getting back in front of the Planning Commission and the board with recommendations.
So I'd like to ask Jennifer for her input.
I want to work with you all to determine what makes the most sense. I do have a real life example, maybe that will help put a few things into perspective. So some of these big projects, right, a new PUD or something like that, anything, if it goes through 3 or 4 rounds of review, I have concern putting in the first submittal and the second submittal and the third submittal and the associated comments with those, because it's really confusing for you all to see a first round comment that is subsequently addressed and so it's no longer applicable. The goal is not to hide that from you all at all. It's that it has already been worked through, and I do think it's really confusing if all that is in there. And so that's an example that I would love to hear from everyone about how can we come to an agreement on how to address that in a way that's effective but informative, but not confusing for you all or for the public who may open the packet.
Well, when the 4th round of review that's when the application is deemed complete, correct?
No, sir. So there's a difference in completeness and ready for public hearing. And I think that's one of the heart of some of the confusion here. Completeness is on the very front end, and it's before it even goes out for referral. And it's basically saying, you've submitted these documents that are outlined in the regulations as being required. The things, right, like the tax statements and a deed or lease or whatever like that. So those are required to come in. I don't think a lot of our referral agencies look at those, but they look for their independent, for their area of expertise, right? Fire looks at, access and where hydrants are and things like that. Public Works looks at different things. Different agencies at the county look for different things. And so it's those rounds of review and resubmittal is different than completeness. And so that word completeness, I feel like, is causing a lot of confusion. Completeness on the front end is simply, has it been turned in? Now, I will also look to Lance and apologize for putting him on the spot and not necessarily need an answer today, but my understanding and my professional experience is that there is a difference in it is turned in and is complete versus it is a legally defendable document, right? Is that lease agreement legally binding? That is not a determination that I would argue that county CDS staff makes. You know, was that a good arrangement or a bad arrangement, or, you know, did the proper person, that's the right person from that entity, sign that? I think that's a difference in that level of legal review than completeness, and maybe that's part of the confusion as well. And again, if we need to handle that differently, we're happy to do that. But completeness is on the very front end before it can go out for referral. Payment of the application fee is an example of an item required for completeness.
So I would be cautious with that, because in my professional experience in telecom, which has a federal mandate, and Lance, you might be familiar with this, if the county is going to deem an application complete without the review process, I'm going to start the shot clock on the county without any of the tolling agreements. From a federal law, like a eligible facilities request, and I'm just going down telecom because that's my background. So if I submit an application to you, right, you have a 30-day shot clock to review that application. But if you're saying that that application is deemed complete upon payment, I think that I'm just saying, I think we need to have a clear understanding of that, because if I'm an applicant and it's deemed complete on my side and I have a federal shot clock behind me, I will continue to run that shot clock.
So
deemed complete.
Payment in and of itself, that was just an example of one of the things that has to be checked off.
100%. No, I agree with what you're saying, but I'm saying you're saying application is deemed complete and then you start review processing.
I'm saying that's how the regulations read for land use applications. There certainly can be an exception for.
And that's what I just, because there's multiple different federal shot clocks at a deemed complete application.
1041 is also different, but.
So I think, what is the deemed complete?
And I think this comes back to issues that we're finding with the way the regulations are written, because the zoning regulations, as far as applications submittal, it says that, very clear, the CDS department will review the package for completeness. A submittal package is not complete in terms of type, quantity, and adequacy of required documents, will not be accepted for review, and will be deemed incomplete until all required submittal items are provided. But what I'm hearing Kyle say is, you know, we've got gaps in this, or it's not as clear maybe as it should be.
Well, Lance, I'd like to hear, what were you going to chime in?
Well, I agree with Jennifer as far as completeness. That is a determination that's made early on. You make a very good point, Kyle, that certain types of applications, that determination has a different impact. So things that are regulated by federal law, you're absolutely correct. Many of them have time limits for which the county must fully process and approve, or it's deemed approved. And yes, there are applicants that would take advantage of that. But it doesn't change, in my opinion, the determination that Jennifer makes or her shop makes that all of the documents that are required to begin to process that application are present, and therefore it is deemed complete for that purpose. It's just that in some cases that has more significance, and I would argue that in those cases those applications are less likely to change. I've seen many a land use application that started with on a large property, started with smaller lots around the outside, maybe an open space tract in the middle, but they ended up using the open space on the outside to create a buffer with adjoining neighborhoods, then larger lots, and then the smaller lots kind of in the middle and contained. Now that application changes an awful lot from initial submittal and completeness to when it finally goes to a hearing. But that doesn't mean it was incomplete when community development determined the application was complete to beginning processing. But the point is, during processing, things change. Elements get dropped, roads get moved, lot sizes change, areas change, a lot can change, and then what goes to a hearing is not identical to that first thing that was called complete. It's a revised application that now is ready for hearing. So we're not really talking apples to oranges, but there is a different impact for completeness for some types of applications than others.
Well, it just led me back, and actually kind of circled around, but back to Jennifer, where if there's 4 reviews, I don't want to see reviews 1 through 3. I want to see what my wording would be, a deemed complete on my own language application, which would be the fourth review completed. I don't need to know that the applicant then, increased 100 by 100 square foot on their on their PUD.
Right, no, I'm with you on that, because I get to the point where it's a 4,000-page document, and you're going through, page 2,000 through 3,000, and a lot of it's repeat. And
Well, then it's also reviewed, it could potentially be reviewed incorrectly by us on the board, where
Correct.
one of us is talking about a completely different thing because we saw this language from 7 months ago that was obviously incomplete or part of the review. So, no, I agree with Jennifer.
Well, and just to add to the conversation, though, as someone who's wanting to know what the feedback was, I like reading the narrative to know that referral agency had a concern and the applicant addressed it in such a way. So I prefer to see that narrative.
But isn't that narrative part of the final package that's presented to us?
Aren't we still seeing the referral comments?
Yeah, we're seeing the referral comment and the response, right, in the final package.
Are you stating to remove that? I don't think that's what you were saying, right?
So my proposal would be to include the final review comments that say all of our concerns have been addressed versus the first one that had 27 concerns and the second one that had 13 concerns, right? And then the third one had 3 more concerns. And then, so we can include all of those, but it's not going to make sense, right? If the first comment says, the lots are too small and don't meet the requirements, and then the plat you have does meet all the requirements. And so that's something, again, willing to talk to.
It's not germane to making the final decision.
No, for a split second I was going to disagree, but you're right. I mean, I'm not fire, I'm not water. I'm not an expert in those areas, so I don't need to know how they determine what is on the instance that they're complete. So yeah, I still agree with that.
So I think really in your terms, what you were saying is complete is really outside or agency comments, referral comments resolved, right?
Yeah.
And we certainly try to say that. And there are a number of times where sometimes those aren't all resolved, and we'll certainly point those out to you, right? Or there's times where the applicant disagrees with, right, a certain department or agency about how to resolve that or if it's resolvable. So those would certainly be made aware to you of that, but I think that that's different than
fire coming back and saying we have no concerns, everything's been met.
Right, they did what we wanted them to do on this latest
board,
submittal.
we need to then take that as fire reviewed. Yeah, I agree.
We have to trust that. Yeah.
But I think that if there's 52 things before and fire had worked those out, I don't think it's going to then change my opinion on the approval criteria if I don't see those 52 things.
It's not germane to the final decision.
So, for example, I've never seen, since I've been on the board since January, I've never seen a referral agency come back with 52 things that needed to be done. Usually there's a few, but often what we'll hear during public comment, for example, is concern about migratory patterns for animals. And we will see that state agency got back and said, we are also concerned about this. We recommend the following, corrections or special ways to address the migratory patterns. And then you have the applicant respond with, okay, we're open to that, we'll adopt these policies. And then you have a response back saying, great, then we have no other concerns. I think that narrative is not only important for our decision-making of criteria, but also for the public to know that these were concerns raised at the referral agency. The applicant had a response that was open to addressing those concerns in the way that the referral agency suggested, and then there was no problem. But all that narrative is information that's helpful not only to meeting the criteria or being able to know whether or not the criteria was met, but also for the public to know that we're following the referral agencies and the criteria.
Can we meet common ground here and do the concept of an appendix where we drop the history associated with the discovery that was done, the referrals that were done, the elements that were done, in a section that is separate and distinct from the final package that allows people to read and follow the pattern associated with the questions that were raised and the concerns that were addressed but at the same time allowing us to focus on the things where we landed to get us to a point where we fully can judge the case.
Well,
Basic, like an audit trail.
well, better yet, can we meet in a common ground where if there's an issue that needs to be fixed for the application, that's fixed, but if there's a recommendation for migratory birds as part of the approval and part of the requirement to build, that's still inputted in there. Like when CPW provides recommendations, having the applicant say, okay, I'm going to do that. I agree with Nicole. I think it would be cool to just see, hey, these are the recommendations from CPW. But I don't need to be, CPW says you cannot add this 10-foot fence, and then they remove the 10-foot fence. It's not a recommendation, that was a requirement.
Yeah, so some of us don't want to see the sausage being made, but we do want to see the final product. Right. And that final product includes that decision that occurred. So I like where you're going with that.
Yeah. For the recommendation.
I'm going to jump in here. There was an issue I wanted to address earlier, and I drew a blank, and I apologize for that. But there's kind of a question about minutes and how the Planning Commission's recommendation makes it to the board. And this is something I want to get out there just for board consideration, because I think it's something you're going to need to put some thought into and then get back to staff as far as what you want to see. So minutes, as we've discussed in the county, are summaries of action taken. That's how Robert's Rules defines them. So if there was a debate and then a motion, then the fact that there was a debate and the fact of a motion and the exact motion would be in the minutes. But certainly everything that is said does not make the minutes. When you are talking about everything that was said, that's a summary of what was said, not what was done. But minutes are all about what was done. That's what Robert's Rules defines them as. And the county has started, at least with the board, and I think with Planning Commission minutes as well, to go to action minutes so they are what they were intended to be. And those can be supplemented for anyone that wants to dig further with the audios of the meetings and other things. But I think the question's kind of been stated, not asked. At least some planning commissioners feel very strongly that their reasons for their vote need to make it to the board. And so I think the board has a decision point it will need to make. What does it want to receive? What does the board want to receive from the Planning Commission in order for the board to start its own decision-making process? I know that now, I think I've seen Planning Department, Community Development, will present a summary of the concerns of the Planning Commission when they give their staff report to the board, and I don't know if that's adequate. You could certainly have the audio of the Planning Commission meeting made available to the board. There's an AI function of meetings like this that takes a transcription of the meetings that could also be made available to the board. But it's all more information, and if it's made available to the board, then it needs to be in the packets. It needs to be made available to the public. It needs to be made available to the applicant. So somewhere in there is the amount of information that would benefit the board, regardless of the preferences of the Planning Commission. I think the board needs to consider what that should be, because that information is prepared ultimately for your benefit.
And frankly, it's an interesting point, because we have gone back and forth several times about when we vote no, when we vote yes, supplying a reason to feed that back into the Board of County Commissioners for an understanding of why our recommendation went the way it went. And so to me, that's kind of the benefit of what we were trying to accomplish with that. And I'm happy to take the board's recommendation if that's something that is no longer needs to be considered. But I think it does give context, and that's a missing link.
No, I agree with, I like knowing why there was a yes or a no from the Planning Commission. If the reason is because the guy wore a yellow suit and I don't like yellow suits and so I voted no, then I know that that's probably not something I need to pay attention to. But if there's something that's serious that I need to look at, I appreciate that reasoning behind. I don't know what the other two guys think, but that's my thoughts on that.
And
Mr. Chair, if I could just ask for Lance to give feedback. I know that Douglas County does minority reports, or so anyone who votes in the minority, that they would submit something in writing about why they voted that way. Is that something that you would recommend in Elbert County?
No, I appreciate the question. I guess I'm not really making a recommendation because I've asked the board to consider what's most helpful for them. So I'll make sure they understand your question because that might be the option that they prefer. So when someone votes or has concerns about an application, would the board find it beneficial if they individually summarized their concerns and got it in the record that would then go before the board at a later date? So there's a number of ways, again, to see the Planning Commission's recommendation. You can see the motion and the vote as would appear in action minutes. That's kind of the minimum that you would receive. With that, you would undoubtedly receive at least a summary from your planning department when they present the application to the board. So again, I think that's at the minimum. At the maximum, you could get an exact transcript or audio tape of the Planning Commission hearing, and you could listen to the entire deliberation and vote. And then there's things in between. And I think I would summarize Nicole's offer as something more in between. It's not the minimum with the summary from planning. It's not the maximum with every word verbatim, but it's a little more information for those that had concerns that they can document those concerns for the board. I don't have a preference. I'm not a decision maker when it comes to the board. Whether you vote for an application or against it makes no difference to me. What matters to me is that I have a record I can defend, so whatever decision you make, it's something from a due process and legitimacy standpoint that I can defend if challenged. That's all I really care about.
If I could throw one more thing in there, and that's all great. That's good information. And this again comes back to the documents need to be updated. They're, we're supposed to be using zoning regulations to whatever extent everybody decides that's supposed to happen. But in regards to the meeting minutes, and this is again lined out in Article 1, Section 4, where it talks about the Planning Commission. Number 12 in there talks about the secretary to the Planning Commission's appointed by CDS. And it goes on to say, the secretary shall take the minutes of the meetings in an appropriate manner approved by the Planning Commission, and then, they get made a matter of public record. So to me, in a lot of cases, the question comes to, do we just ignore something in the zoning regulations because we don't like it, we don't think it applies, that it becomes subjective? Or do we back up and say, we need changes to the regulations, and that change is what will drive how we make our decisions? Or are we not bound by the zoning regulations?
I guess I'll treat that as a question to me. Minutes are what minutes are, and so having minutes prepared for the Planning Commission that says what it says. I don't necessarily think the only interpretation of that is when the Planning Commission accepts the minutes, it has to be in an exact form that they like or prefer. It means that they be accurate and they reflect what happened at a meeting, because minutes are defined again as action minutes, and they need to define what happened at a meeting. So an applicant presents an application. The Planning Commission asks questions of the applicant. Ultimately, a motion is made and a vote is taken. Those are the actions that occur in a meeting. What is said is not action, and that's outside the scope of minutes. And so I read the same language as you, Diane, but I don't reach the same conclusion that the only way to do it is the way it's been done in the past. There are different ways to do it, and ultimately it matters what the board wants and needs to make its final determination, far more than anything I interpret from this.
Okay, so let's move forward. Ideas that have been presented is to have a subcommittee to work with CDS to come up with at least a minimum standard, and then also to be included with that minimum standard is based upon the current rules and regulations that they have the authority to make the determination that a package that's being presented to us posts all the referrals and everything else, and also the determination that the package was complete upon initial presentation, that's what we use to make our decisions going forward. Now, one of the things I would ask is, based upon the complexity of the package or complexity of the application, should there be a tiering of the minimum, required documents that are presented at the time that the package is delivered to the public and to the Planning Commission? That would be, something that we can discuss in the subcommittee. So do we need to have a decision or a vote with regards to that subcommittee? I don't know what the rule would be.
Great question, because I look at this as a working group session.
Yeah.
We don't necessarily need to vote, but we do need to agree at some levels. And Dallas, you want to weigh in? Go ahead.
I would suggest that we give discretion to the chairs of both boards to assemble the committee.
I like that idea a lot. And we'll take that off and report back to this group and get a subcommittee rolling on that. So fantastic, thank you.
Well, and last thing on that is if you have 3 or more on the subcommittee, it will be subject to the open meetings laws, so it will have to be noticed at least 24 hours in advance. 2 or less.
More than 3?
3 or more, yeah.
Okay. Fair enough.
Even if it's not a quorum from either body?
The open meetings law defines a quorum as 3 or more or a majority, whichever is less. So for a Board of County Commissioners, it's always 2. For any other body, it's 3 or more. Constitutes a quorum for purposes of open meetings notification.
When we're combining 2 different boards, how does that affect it?
If it was 1 commissioner, for example, and 2 planning commissioners, it's not a quorum of either body.
Okay.
I like that. Okay, perfect. All right. Do we have any other business tonight other than heading back to the house? I don't know that we actually have to have a motion, but thank you everybody for attending. I think we discussed a lot tonight. We cleared a lot of the air. I think we have a plan going forward. And Byron, I'll reach out to you and we'll start that next level discussion on a subcommittee.
All right, sounds good.
All right, thanks everybody.
Hey, thank you, guys.